Hello, this is Alexander Cross with Law Offices of Cross & Associates Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross & Associates. So we received an interesting inquiry here on our YouTube channel. This has to do with a domestic violence when the victim was a minor. Criminal attorney, Redwood City. Domestic violence attorney, Redwood City. Accused of domestic violence, Redwood City. Let's see. I argued with my girlfriend and I punched her. The police arrived and they arrested me. They realized she is 17 years old. Double problem now. What will happen? Well, first of all, let's focus on the domestic violence part. Domestic violence is obviously when you touch your spouse, ex-spouse, girlfriend, ex-girlfriend, or somebody with whom you've had a relationship with, when you commit a battery upon that person, harmful or offensive touching. Now, you don't need to actually punch or impact the victim. Simply touching the victim during the course of an argument would classify that touching as offensive, and under Penal Code Section 243, parentheses E, parentheses 1, that would be a misdemeanor, which carries up to 1 year in county jail, plus having to take domestic violence classes for 52 weeks, which is a year, once a week. Now, if there's an impact and there's damage, broken bones, cuts, bruises, that sort of thing, reddening, well, now we're talking about a violation of Penal Code Section 273.5 as a felony that carries up to 4 years state prison, plus having to do those domestic violence classes. Now, you also have to understand that if you're not a U.S. citizen and you commit this offense, this is considered a crime of moral turpitude, which means it could result in deportation, exclusion from the United States, and denial of naturalization if you are not a U.S. citizen. Now, regarding her being a minor, the other issue is the relationship itself, because the police may question you. That's why you should never speak to the police. Never give a statement to the police, because anything you say or do will be used against you in court, although she might give a statement. Problem is, if you have a sexual relationship, good bet that you probably did have a sexual relationship, well then now we're talking about a violation of Penal Code Section 261.5. If there's less than a 3-year age difference between you and your girlfriend, well then that would be a misdemeanor, which carries up to 1 year in county jail. But if there's more than a 3-year age difference between you and the victim, provided that you are the adult, well then now you're looking at a felony under that same code, which carries up to 3 years state prison, plus having to register as a sex offender for life. That's something that is a very, very real possibility if you get in trouble for domestic violence and it comes out that your girlfriend is underage. Remember, it's not rape, it would be statutory rape because it's with the consent. It's just that the consent does not have validity due to the age of your alleged victim. The other potential charge, although it is a lesser included offense, well, not really lesser, it's actually more so. The other charge would be child cruelty, which would be a violation of Penal Code Section 273A, parentheses A, which carries up to 6 years state prison. So the DA could charge with that offense as well, in addition to the domestic violence. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates. But if you've been accused of a crime and need representation in court, call us now for a free consultation, 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who's looking to do record expungements for some old cases. Criminal attorney, Redwood City. Domestic violence attorney, Redwood City. Statutory rape, Redwood City.